Thank you very much for this opportunity. By way of self-introduction, besides being director for maintenance, and I should actually indicate that this should be seen as a positive move on the part of the department. Because since 1998, maintenance has been a sub-directorate. When you say it's a sub-directorate, then it means it's a sub-program. It's a sub-program that is led by a deputy director. As a result, you do not necessarily, I'm not saying deputy directors are not strategic, but you do not necessarily have the critical mass of thinking around how to turn around the environment that legislation is trying to deal with. So we should applaud the Department of Justice for taking a very bold step to actually establish a directorate, an entire directorate, to look at one piece of legislation. It doesn't come very often in the department or in departments that you'll get one highly paid official to look at one piece of legislation. So what does this indicate? It is an indicator, isn't it? It is an indicator that the Department of Justice recognizes that there is a problem in maintenance. And it also recognizes the fact that maintenance is located within family law. And if it's located within family law, what does it mean? If the department is going to stay outside the mayhem that is within the family, they're not going to succeed very much, because that mayhem will come to our courts and will give justice a very bad name if we cannot really handle the mayhem. So by way of introduction, I wanted to say that the department has taken that bold step to acknowledge that we need to have a grip on maintenance as a form of dispute resolution within the family. Secondly, by way of my own introduction, I'm very excited. I'm sorry, Pastor, and everybody else who came before me. I came a bit late at 10:30. I did not have the foresight or the earsight of your presentation. So if I happen to repeat what you have said, please forgive me. But I come from a conflict resolution background. During the transition to the post-apartheid South Africa, I was part of which was an NGO that worked in dispute resolution. So there was a huge dispute resolution movement at that time within the communities as well as in the labor sector. So I'm excited because I'm seeing a kind of revival of dispute resolution. And for us as the department, I think it's important that we embrace the movement. Hence, we are really in the process of raising a memorandum of understanding to partner with social justice to make sure that whatever capacity we can get, actually look at how to resolve the majority of maintenance disputes outside of the court. We are able to do that. Whatever capacity that they have in new technology, we can utilize that. So I'm done with my self-introduction. I would like to, they said I mustn't move and I'm a presenter that knows a lot, but I'm really mindful that there are people online who are part of this conference. As I was preparing for this conference, my mind went back to the Valentine case. And I thought that I should just grab a little bit of the feelings that the judges had about the state of maintenance dispute resolution in the country. And when I say dispute resolution, I mean from the court's perspective. The words of the constitutional law judges in Valentine versus Valentine and another, really, for me, it should touch our souls. For those who work in the in government departments, hearts, minds, and it must propel us to action, to tireless action. The words of the judges said, systematic failures to enforce maintenance orders have an impact on the rule of law. And this is what I was thinking. That if we cannot take care of the families, then it means disputes within the families are going to spill into communities and from communities into society. And when they do get out of control, then we say that the state is safe. Then the courts are there to ensure that rights of all are protected. The judiciary must endeavor to secure for vulnerable children and disempowered women their small life-sustaining legal entitlements. If court orders are habitually evaded and defied with impunity, the justice system is discredited and the constitutional promise of human dignity and equality is seriously compromised for those dependent on the law. This could never, it's nearer to the truth. It is the truth of, I will appeal for us as state or government officials to understand that when we play with the rights of those who come to courts, when we take our time to act expeditiously around the rights of those vulnerable children and women who are predominantly custodians. It has been said, and I think Luri might have touched on it, to say that there is a high proportion of custodial parents are women. As a result, the burden, I'm going to put it in inverted comma, because it's not a burden. The duty, the heavy load of taking care of a child, it rests on a woman. And that has financial implications. And I can tell you that I a single parent, let me not say never. I have not had the opportunity of having assistance from the father of my children, or even my grandchildren. So the burden falls on me. I can go back financially and say, When I had my firstborn child, I could afford 1, 2, 3 kids. I could afford holidays. When I had my second child, she could go to a private school. Now, my last born cannot go to a private school. My grandchildren cannot go to private schools because I'm carrying the financial burden of being a sole provider. So this is a real issue for women because it makes us eat. The lack of enforcement of those rights feminizes poverty. Because out of the street, anytime when the banks decide, no, we want our money now. So it's 20 years since the Banantine matter, and we still, I don't want to acknowledge it. I just say we seem to be still at the same time. But we can underline that seem to be like, I'm just being politically correct. It is really, really bad, the extent to which we fail women and children out there. We would like to apportion blame at some point of the day as the Department of Justice were the mother of all institutions that are responsible for maintenance. So to take the leadership by the thing, hence the department has appointed a director. Now, I must contextualize this from the fact that when we talk about conflict resolution and mediation, in matters, I call it, you remember long time ago, when I was working as a deputy director in domestic violence, I called her to do mediation in maintenance matters because I came from a mediation background. I couldn't use it in domestic violence because at that time, I could say that it was inopportune time to say that in domestic violence, we should intervene. I think it's still the policy decision that we don't use mediation where there is domestic violence. But I think it is an opportune time now to open up GBV to mediation and conflict resolution. So we worked around this because I recognize that disputes, there are elements that run through all forms of family disputes. Both parties are normally indicating that they are traumatized by their dispute. Both the man and the woman, they have their own traumas about the taking care of the child, about divorce, about domestic violence. Both of them have their own traumas. The one might be having a trauma of having abused the victim, and the other might have a trauma of experience. Maintenance is still the same. Somebody has a trauma that they have to deny paternity. It's a dispute. Ne? They must go to court and prove that they are not the father. It's trauma. You don't just walk in. Court is not a walk in the park. Perceptions are from a personal survival perspective. People want to hold on to their positions. In family disputes, it's even worse because there are relationships beyond just you and me. There's mom and dad on this side, mother-in-law this side. There are Gogo, there are uncles, and so on. So when you fight, you come with ammunition of self-preservation. Your image around these people must not be shattered. People must see you, whether you are a complainant or a respondent. That is inevitably a position that you take. So people take position. So it's very difficult to come and confront people who are sitting there saying that my position is going to be this because I've got to present an image that says blah, blah, blah. Whether it's true or not is another issue. Ne? Then there is a psychological impact on the different individuals involved. In divorce, it's not only the mom and dad, the children are involved. In maintenance, it's not only the mom and dad, even the child is involved. So psychological impact is something that we need to take care of. And in court, we normally don't do that. And I can tell you that I have assumed that I'm a fake counselor. I've never been trained as a counselor. But I've allowed myself to listen to women who are frustrated by the system. I've opened up myself on weekends to try and talk to children who are breaking down because their fathers, in the process of fighting the maintenance dispute, also fight children because they say, if you do not abide by what I say you should do, then I'm going to withdraw. I'm no longer going to buy you soccer boots. I'm no longer going to come to your soccer. And the child will say, Mama, let me talk to Mama Kamogelo. And you hear even in the voices of the complainants that, oh my God, sometimes I also take what we call transfer trauma. I sit in my bedroom. I don't want to see anybody in the house because I've listened. There's one client, I listen to her Friday afternoon every day from work until I get home. And then we have a break. Then after 9, when she knows that we are done, we have another session. But I get paid for that, and I now am beginning to learn how to self-debrief because otherwise I'll stay in the bedroom all the time on the weekends. So this is a very real thing that the courts need to understand, that those who come to court, they come to court with those positions, with psychological trauma, with all these kind of things. The social, cultural, economic, religious dynamics often cloud the outcomes taken in court, whether through the courts or outside of the courts. So when the father is, I don't want to use the magistrate, when the father is a well-known taxi owner, I like bashing taxi owners, but it's not all taxi owners that don't take care of their children. The well-known taxi owner, you see, when he appears there with his guys at court, you see the there, hey, and so on. And when the wife comes in, they say, "How? Ufuna mali, ufuna 30,000 rand. I told. That's too much for her." You see, already the social, cultural, economic conditions also cloud our people in court. And I'm saying this as a matter of self-reflection to say, as we do transform, we must infuse our training with sensitivity to make sure that people understand their own biases. Now I'm talking conflict resolution. You must understand your own biases so that you can remain neutral. But if you do not have that ear and understanding of bias, and that you come with a social, economic, and cultural bias, then you're not going to serve the public correctly. In view of the fact that maintenance disputes are deeply emotional, there is therefore a need for role players dealing with these matters to have certain level of maturity, skill, and ability to diffuse those different levels of conflict. So you can imagine, I often, hey, I'm gonna talk bad about my bosses, you know. I sometimes feel really say, oh, really, Mr. Example. They'll say, no, we'll get clerks, interns to come and help maintenance officers at the front line. And I'm like, no. Young person who is just a child who finished 4 years at university, you want to come and put them there? They have no clue about relationships. They have no clue about marriage. They have no experience about life. For them enable people to dispute at Section 6 level. If they don't have that experience, then that dispute is going to go into court. I'm glad to actually say that I did take time to look at my statistics to try and find out the level of resolution of conflict or of maintenance applications. And I realized that most of the applications are dealt with at Section 6 level, which means that mediation skills, if they are properly given to these frontline officials, even the entrance, we can kind of give them crash courses, advanced courses, refresher courses, focus on them so that we make them get matured speedily in resolving conflict. I believe that if we are able to have these skills, then they will be able to diffuse most conflicts at this level. It is also very important for role players to have conflict resolution. I've talked a lot about that. For role players to have higher levels of sensitivity and understanding of what is required to breathe life into Section 28(2) of our Constitution, which requires that the best interest of the child must be of paramount importance in all matters where the child is concerned. People tell me that they know this thing. But when you look at the statistics, you know, when I do my annual departmental plan, I've got a target that says we check from the date of proper service of the respondent, we start checking. You must complete that case in 90 days. We are hovering between 88 and 89% success rate. Out of that, there's a high majority of the cases that dealt with at Section 6 level. There's 11% that we fail in terms of the target that is set for me. I think it's 92. I failed by 11%. It means that 11% goes to Section 10. It goes to court. Then once it goes to court, then it means we are not able to reach the target of 92%. Now, in court, if we have 11% of those cases stuck in court for 135 days or even more, then the perception of justice is at stake. Then it means those who are dealing with the cases do not understand that provision that says it is of paramount importance The solutions, I'll go to them, but confession is very therapeutic. Ne? Yes. I'm confessing our sins. So I have a case, one of those cases that I'm carrying over weekends, and even I leave my work and attend to them and make sure that there's a good referral to my networks. That case, I'm going to demonstrate how conflict maintenance disputes are. My miss is a businesswoman with a father, with the husband. They make a lot of money. They move from a location to a suburb. Later on, years down the line, when they have the first or the second child, who's about 18 months, he decides that he wants another lady to come in and take over, and kicks out the wife. She says she literally took the 18-month-old child and started walking to court, believing that once she gets to court, a decision will be made so that the court says this man must find accommodation and everything so that she can be somewhere with the baby who's 18 months. Now, the complexity of family matters is that they are intertwined. When we talk about custody, we talk about maintenance, we talk about maintenance, spousal maintenance, we talk about economic abuse. All those things are interlinked. I am so saddened that this lady, the child was 18 months when she went on the street. The child is 14 years. Sure. They are still in the system. Wow. I cry sometimes when I'm with this lady. I give myself the time to be a human person. Yeah? And not take the head of an official to and say, I'm not too sure what is so wrong in the system. This revolving of you coming in, coming out. There was a time when from the age of 2 or 18, the children were staying with their father because she didn't have money, she didn't have accommodation. She is back staying with the in-laws just so that she can stay with their children. Can you understand the dynamic that you are reduced? It's secondary victimization. It is major secondary victimization. And I sit and ask myself, how we justify? Sometimes I want to protect and deny that there are no cases like that. But I have one in my office. It's there. I know the person. I sit with the person. You see, when you look at statistics, it's easy to hide and not know. But when the client comes in and says, I want to see the person responsible for this, and she must have, you got to see that person and acknowledge the fault lines in the system. And I can't say that I'm a Rambo. Sometimes I'm not listened to. When they say they're gonna bring an intern because we'll give you a click. We will get clicks from there to work with you. Honestly, with the magnitude of the problem that we have, I really do need a deputy director of solid 10 years experience being a deputy director. So that when we talk about moving and doing things fast and thinking of solutions, I don't have to start taking and then babysit them throughout. So you see the systematic challenges that we have, and it's even more of a scary situation in this austerity measure period. But I believe that with a little bit of resources that we have, be the gaps or whatever, we're going to have to do some of the things that are very critical. The second level of sensitivity that is required is the financial. We need to know the financial impact of non-payment of maintenance on custodial debt. I said a lot about dispute resolution, but I think we also need to understand that maintenance dispute, they range. Remember, I told you that almost only 11% of those cases go to court. So the majority are dealt with through Section 6, where we use, is an informal inquiry where the officials, although it's an inquiry, they use the skills to make people to come to agreement. I'm beginning to hear complaints. 1 or 2 complaints have come through to say that I agreed to be paid 300 rands because I was forced by the maintenance officer. So it means I must go back to the drawing board and get my partners. SJ, Eugene, you need to come on board. Lienki, you need to come on board to the training because obviously there is attrition rates and maybe some people didn't go through the mediation skills training that we did. I would like to now talk to the real issues of challenges that we have in maintenance. Often, I think even people who are married, in some families, it's very rare where you find that they bring their salary slips or their financial statements on their table and say, okay, you earn this much, I earn this much, let's work through our finances in this way. Often we keep our salaries, financial statements to ourselves and agree that you will do A, B, C, D, E. And then you say yes or you say no until you come to some agreement. So often, whether people are married or outside of marriages, people don't know really the financial standing of their partners. And yet in maintenance, we want to know how much do you earn, how much does he earn, so that the magistrate can come to a quantum that is appropriate for whatever that you're getting. So with those 11%, they make a lot of noise. The 11% that is not resolved through Section 6, they are hard cases. They are medium complex to hard cases. We find that we had one case that we dealt with. I work with a national Osmonica Ngomani Mashele. She has been a maintenance investigator over a period of time. Once she gets a case, hey, she acts like a bulldog. She will she'll hold on to the case until she's satisfied that all that she did in investigation was taken into consideration. If it's not taken into consideration, she'll push again until we will go and meet the magistrate and say, you didn't consider A, B, C, D, E that was there. And some of them, they will say, no, take the case to appeal. Some of them will say, no, let's get it back to the magistrate who was dealing with it so that these facts are taken into consideration. So most of our stumbling block or obstacles are there. What have we done? There's also third parties, employers who refuse to details of their employees. Hey, sometimes they're even our government institutions. And I'm like, don't you understand? Section 9 of this Maintenance Act says 1, 2, 3. We've written a letter. And they'll say, no, we're not giving you. Because our principal act does not allow us to do that. So we have third parties that refuse until we set them with summons and say, go to court and explain to court why you cannot give that information. That adds on to the turnaround times in clearing these 11% cases. We've got a problem with the unbanked people and even businessmen. The unbanked people who work in informal economy, they work with cash dollar bills. They don't even go to the bank. They buy things cash, and we can't trace their financial spending because there's no track record that we can draw from. Then we have to look at, hey, how many cars does he have? Oh, and now they're 11%. They are clever. They even try properties in their new wife's name so that we cannot get our hands on it. And then we have to go to court and present to court that there's no way this guy who got 2 million rands in November, that 2 million rands is gone in January or February. This woman has this kind of property and property and property. You know, by then the anti-dissipation order, if we do application for anti-dissipation, that money is gone. I tell you, a guy got money in December, February, there was nothing. 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 We went to all the banks we could not find until we presented to court to say it is not possible. There was dissipation, but we know that the wife has let us call her to ask the house cash, the car cash, everything. That is the only way. Courts take a long time. So the 11% is making us scratch our heads. What are the possible solutions that we can embark upon to deal with them? Currently, we're using the maintenance on the system, and that allows us to get some level, not true, some correct financial position of the person. You will be able to accounts that they have, the value of the house, the value of the car they drive, and the lifestyle. You basically could do a lifestyle search and afford to pay for these things. Therefore, he can afford for the child's maintenance to this amount. Then we are often compelled to subpoena. Sorry, I used summonses, it's not summonses, to subpoena parties have to come to court. Now, the emerging trend from, we had a workshop in June, very height of winter, where we explored what are the possible solutions that we as the department can draw from to unblock these obstacles. We realized that we have to collaborate with banking institutions. There is no way we can do it alone. So we need banking institutions because they give credit and deplete whatever monies that the persons who are supposed to pay maintenance have to use for maintenance. Then we also are currently of capacity is that you need to understand, not to be sympathetic, but to understand that when a unit is undercapacitated, There's so many opportunities that pass because you don't have the time to dedicate very important things to those things. We had a development of government person verification system. The person verification system will be drawn from all the departments have information about us. All the departments. Home Affairs has information about all of us. Department of Health has information about us. Department of Labor has information about us. SARS has information about us. So what we are trying to do is to collaborate with all these departments to enable us to draw. If we get information that you are a respondent, we must be able to plug into SARS to check your SARS liabilities and what you're doing there. Now, if you are engaging with transport, for instance, we must be able to go to the municipality to see how many cars are paying for licenses so that we can draw that information that you're hiding. Ne? Yes. So the person verification system is beginning to build the capacity of having centralized information about to enable maintenance investigators to plug into different departments when they want information about a person that we cannot track at credit bureau. You see. I can see somebody is very excited. They want to ask a question. Do you have a question?
Yes.
Yeah.
Sorry, but what about the POPI Act?
Okay. In terms of the POPI Act, there are several provisos, justifications. The Act, a legislation to do what you are supposed to do. Like, for instance, Section 7 gives maintenance officers and maintenance investigators to go investigate the personal and financial information of persons. Then they cannot use a POPI Act. But we also have to comply if we have to publish your details, like if we have to put them in the credit bureau, we will let you know that we are going to put you in the credit bureau because you failed with enforcement order, and then thereafter we'll put you in the credit bureau so that your credit points can start wobbling. Then we also have a challenge with uncooperative parties who are litigious. They will raise technicalities at every corner. They will go from one court to another. We have one case where Osmonica was, Osmonica said to this guy, we're here at High Court. You have 7 lawyers and 2 advocates. Don't you think with that money that you're paying those people, you should just take the money and pay the areas? Just from where I'm sitting, it doesn't make sense that I'm here presenting a report in High Court. And when she left there, the High Court said, attach 300,000 from this bank account and attach the million that is coming on that bank account. That's the million that was gone by the time we came. The same person still refused to pay the million that, or whatever 2 million that he owed, by moving money around, and we had shown that he moves money quickly from here to there, and the act of deciphering that also takes time. Maintenance investigators of Labrador. She didn't let go. I like her. I like people who stand for their rights. Then she said, but again. And I've gone to all these courts to try and get money, and this person is not paying. Then she went to in Mafikeng. And you know, the High Court made an order and said, you are in contempt. We are seeing your trail of refusing to pay. And now you're refusing to follow our instruction that you must pay this. Man, you're going to jail for 3 months. That money came out very fast. That money came out very fast. So those are the challenges. But there are other challenges that are process-based. And I'm going to quickly go through them so that I finish my presentation. We have delays resulting from application mismanagement, resulting in monies and assets that can be attached, being dissipated. This creates officials and respondents. It's a very, very thick perception that is there, and we are asking people, if you know that for sure, you can give us evidence. Come and give us evidence so that we start dealing with these people. There is a practice of freezing and unfreezing pension funds. You see, when a person gets pension funds in terms of section 26, is it 26.4? We can attach it as if you are in area, ne? And sometimes we even use it for future maintenance, where we have seen that you are a recalcitrant maintenance payer. So here in this instance, when people get their pensions, they try to bribe. I think they do bribe. It's just that we don't have evidence. Because if we freeze an account, we freeze it so that it is frozen until the maintenance dispute is finalized. So if it's unfrozen before the maintenance dispute is finalized, then we are bound to think that there's something fishy there. So these are the things that we are going to be looking at developing policies around. There is lack of formal investigative skills training within our department. Our poor maintenance investigators teach each other investigation, and then we teach them maintenance check and trace, but we don't have a curriculum. And when you don't have a curriculum, you can't begin faulting people for not doing work. Next, it becomes very difficult. I refuse. If somebody tells me, go charge this person because they didn't do this, I'm like, we don't have training program, we don't have code of conduct, we don't have guidelines. So what is the basis of me saying rules of engagement were set initially and you did not follow them? So this is the huge task that I'm faced with. I've got to do those things before I go out of the system in the next 7 years. Possible solutions. We have to establish guidelines for case administration and monitoring in all maintenance costs so that we don't have, okay, apparently I'm done. So I'm just going to ask for a little bit more time because I'll be about to finish. These will close the gaps where we have codified instructions and standard operating procedures, where these are not dealing with these practical administrative and case management issues. Then, yeah, I've talked a lot about people running away from giving us their financial information. So what do we need? We need to establish a joint departmental and NPA policy to address administrative issues not covered by codified instruction and regulations. One will be for the department, the other will be joint because we work together. As there is a need for establishment of framework for maladministration and corruption complaints management. to enable forensic investigation directorate where there is a perception. Now I'm saying, I will not judge you. I will send our forensic investigators to do a fact finding and then make a recommendation based on what they find out. Because when they do fact finding, they're gonna use their forensic investigation tools to find out whether there is a lifestyle that you are maintaining outside of your salary. They're gonna check whether there are people who visit you with envelopes in your home at night, those type of things. We need strengthened electronic investigation tools, including access to information from banking institutions and the credit bureau. We have challenges with maintenance, but this has been dealt with in the review, and at least we won't have these challenges. Some policy considerations that we must take care of is that maintenance is a broad family law matter, is one of the broad family law matter issues. Should we not integrate family law approach to dealing with family law matters in court for a holistic approach? For example, in a DV case where an economic financial decision has been made, economic relief has been granted, often people say that, no, go to maintenance court, don't come to us for economic relief. We need to interlink this. We also have to, will it be correct for South Africa to link private maintenance and social grant for children in any way, shape, or form? We need to come to that decision. Eh? Somewhere, somehow, private maintenance has to of the state for social grants. People must begin to pay, but we need a policy around that, because obviously the guy who pays 300 rands, we can't say because he's paying 300 rands, it's sufficient, you see. So we'll need to develop a policy around that. I believe that the child paternity test contestations are being paid by the state, but there are pockets where courts do not agree to payment of these paternity tests. So we are actually going to have to develop a clear policy on this. The other thing that I think we need to develop policy on is the fact that for those orders, the warrant of execution against property, when they are made, often women don't have the requisite money to pay the cost for the sheriff costs. And as a result, there's property that they can claim, but they can't give the pay sheriff's costs. We must develop a policy on how we can ameliorate this kind of a problem, because if a court order is not implemented, then the court order becomes useless, and the courts come into disrepute, or justice comes into disrepute. I think, in conclusion, what I would like to say is that we've got a relatively good maintenance system. The thing we need to work on is training and educating our people about their rights. It's just tweaking what needs to be tweaked. We need change management processes where we change, we sensitize people. We are going to put, I used to argue in GBV, they said, no, people who work in GBV must be sensitive, we must put it in their in the key performance areas when we interview them. We must check if they are sensitized enough. I have to be a little bit resistant. But now I believe that we need to have people who have the heart to listen to people at home and understand that you're getting paid by the state, and therefore if a person is about to kill themselves or they're traumatized by the fact that they don't have a bread to share with them, you must listen. Even if you cannot help, but at least you must sometimes you come up with solutions to say, hey, Ceci, have you registered yourself in social development, a unit where they give and distribute below poverty line families some kind of assistance? So in short, we have a system that is very, from a legislative perspective, is strong. We need to change our mindset. We need to put systems in place so that maintenance scenario is transformed. And I believe that if we use mediation in resolving some of these disputes and recalcitrant respondents, we will be able to win the battle. Thank you very much.